Hello friends, welcome to Institute of Banking Excellence. Today we are going to talk about scope of banking. Before starting the video, if you like it, please press the like button, share and subscribe it with your friends. Without wasting much time, let's get started. Banking defined in Section 5B of BR Act as accepting for the purpose of lending or investment of deposits of money from public repayable or demand or otherwise, and withdrawal by check, draft, order or otherwise. Constitution of banks. Banks fall under one of three categories. First, body corporate. All public sector banks including SBI Group. A public sector bank is one in which more than 50% of shareholding is held by Government of India. Second, bank under Companies Act. Companies incorporated under Companies Act 1956-2013 and undertaking banking business. For their business activities, these companies are guided and regulated by Banking Regulation Act and RBI Act. A bank, if incorporated in India, is an Indian bank, and if incorporated anywhere else than India is a foreign bank. Third, cooperative society. The state law applies to cooperative banks. If the cooperative banks operate in more than one state, the central law applies. The supervisory function over these banks is done by NABARD. Important sections of Banking Regulation Act. Section 6 defines other business which a banking company can undertake. Remittance, selling buying of foreign currency, purchasing selling of bonds, providing safe deposit vaults, non-fund-based business, execution of trusts, etc. It may establish trust society or association for support of its employees. It may also manage, sell or deal with property/right/title coming to it as security for the loan advanced. Insurance. Section 7, mandatory for every company undertaking banking business to include bank, banking, banker, banking company with its name. Section 8, prohibits activities like trading activities, barter goods for others, etc. Section 9, prohibits from acquiring or holding any immovable property except for its own use. The immovable properties through security of loans and advances shall not be held for more than 7 years, extendable up to 12 years with RBI permission. Customer definition for banking. Customer. PMLY Act defines a customer as a person who is engaged in financial transaction or activity with a reporting authority. Reporting authority here means a bank, financial institutions. It includes the person on whose behalf the person who is engaged in financial transaction or activity is acting. Obligations of banker towards its customer. The certain obligations and rights that a bank assumes when it enters into customer-banker-customer relationship are: 1. To honor checks. 2. To maintain secrecy of the accounts. 3. Banker's right of appropriation. 4. Right to charge interest and penalties, etc. Customer-banker relationship. 1. Creditor and debtor. Customer deposit money in his account and becomes creditor to bank, and bank therefore becomes his debtor. Customer is unsecured creditor as there is no security. 2. Trustee. In case of safe custody of valuables or articles, even while collecting check till the proceeds are credited in the account of customer, the bank acts as trustee. 3. Bank as an agent. Bank acts on instructions of customers like paying insurance premium, depositing monthly installments in recurring deposit account, etc. 4. Bailee and bailer. Bailment according to Section 148 of Indian Contract Act is delivery of goods by one person to another person for some purpose. 5. Lessee and lessor. Bank provides lockers to customer on lease, and relationship between customer and bank is of lessee and lessor. 6. Debtor and creditor. A person takes loan from the bank, he becomes debtor to bank and bank becomes his creditor. Special types of banking customers. 1. Minors. A person below the age of 18 years is a minor. As per Section 3 of Indian Majority Act 1875. A minor above 10 years age can open account. Even 2 minors can open joint account. B. Date of minor be recorded, and on attaining majority, fresh specimen be taken. C. Minor can be partner for the purpose of sharing benefits only. and not responsible. 2. Partnership woman. The banker shall prefer to get her signature attested by the member of her family accompanying her. 3. Account of illiterate, blind person, lunatics. The bank may at its discretion open deposit accounts other than current accounts of illiterate person. The account of such person may be opened provided he or she calls on the bank personally along with a witness who is known to both the depositor and the bank. 4. Trustee. The one who reposes the confidence is called trust, and the one in whom confidence is reposed is called trustee. The person for whom the trust is formed is called beneficiary. A. In trust deed the powers of the trustees are given and defined. These powers cannot be delegated further until and unless provided in the trust deed. B. The instructions regarding operations in the account shall be sought and in the absence of which all the trustees shall put their signatures. 5. Executors and administrators. The executors and administrators are appointed to realize the assets of the deceased and pay off his liabilities. A. In case the person is appointed through will, he is called executor, and if appointed by court he is called administrator. 1. The powers of executor are given in the will, however he has to obtain probate from court before acting as per powers conferred on him through will. Probate given by High Court or District Court extends to all property within the state and property not exceeding Rs 10,000 outside the state. 2. To an administrator appointed by court, a letter of administrations is given to conduct the affairs. 3. Granting overdraft facility. Depending upon the powers through will or letter of administration, the executors, administrators can take overdraft from the bank if provided specifically in the will, letter of administration on the security of the estate of testator. 6. Power of attorney. In general terms, when a person gives power to another person to act on his behalf, he is said to have given power of attorney. The person who acts on those powers is called attorney holder. The powers of an agency are cancelled in case 1. The principal revokes. 2. The agent renounces the business of agency. 3. The principal dies, becomes insolvent or of unsound mind. 7. Joint account. An account can be opened in the name of two or more persons to be operated jointly or by either of them as per instructions of the joint account holders. 8. Hindu joint family. A joint Hindu undivided family possesses ancestral property and carries on ancestral business. The share of a deceased family member is also now divisible among his wife, daughters and other female relatives. The Karta has an implied authority to run the business of the Huf. He can sign the documents alone and bind the Huf for liabilities raised for the purposes beneficial to the Huf. Similarly, the property, if any, belonging to Huf pledged for security of loan will be executable only if the loan raised against this security is for carrying on the business beneficial to Huf. 9. Partnership firm. It is a relation between persons who have agreed to share profits of the business, carried on by all of them or by any of them on behalf of all. A. Authority. The partners, all partners, can give authority to one or more than one persons to operate the account. Such authorized person cannot further delegate the authority to operate the account to someone else. 1. Cancellation of authority. Any one of the partners can give instructions regarding cancellation of authority and bankers act on it. B. Action of one partner can bind the partnership concern, as per Section 19(1) of Indian Partnership Act 1932. The act of a partner which is done to carry on, in usual way, business of the kind carried by the firm bind the firm. So any action taken by any partner, even sleeping. 1. In the name of firm. 2. For the purpose of business carried by the firm. Binds the firm. C. Death of partner. With the death of a partner, the firm stands dissolved. The banks shall stop operations in the account. If the operations in the account are permitted, the credits in the account will square off previous debit entries and Clayton's rule will apply. The estate of the deceased will not be liable for the liability squared off due to credits in the account. 1. Checks issued by deceased partner. The banker shall permit the same only after obtaining consent of all of the existing partners and also satisfying himself that checks so issued are for the business purpose of the firm. D. Retirement of partner. The partnership is dissolved, so the banker shall stop operations in the account as the retiring partner or his estate will not be liable for the liabilities incurred after this date. The checks issued by the retiring partner shall be honored only if issued for the purpose of business of the firm and with consent of all the remaining partners. Reconstitution or dissolution of a firm. As and when the partners reconstitute or dissolute a firm, the banker shall freeze operations in the account to establish liability of all the partners. All the accounts of the firm if more than one shall be frozen and balances, debit and or credit in all accounts, shall be merged to know the exact status of liability towards the partnership firm and its partners. 10. Limited Liability Partnership, LLP. Limited liability partnership is somewhere in between a company and a partnership, that is, it is partnership but still the liability of the partners is limited to their contribution. It comes under the Limited Liability Partnership Act 2008. However, please note that the government has notified that LLPs would be taxed in the same form as partnerships, that is, tax would be levied on the LLP and the partners would be exempt from tax. 11. Self-help group. The KYC verification of all the office bearers would suffice. As regards KYC verification at the time of credit linking of SHGs, it is clarified that since KYC would have already been verified while opening the savings bank account and the account continues to be in operation and is to be used for credit linkage, no separate KYC verification of the members or office bearers is necessary. 12. Companies. A company is an artificial person with perpetual succession incorporated under Companies Act 2013-1956. It possesses all powers for making a valid contract and can sue and be sued. The following documents describe the objectives, powers, rules and regulations, and constitution of this artificial person. 1. Memorandum of Association, also called Charter of the Company. The objectives of the company are laid down in MOA. The banker shall carefully examine the objective because contracts entered into by the company which do not serve the objectives, are not valid and are ultra vires. These cannot even be ratified by all the board members even with a unanimous vote. The MOA also contains name of the company, the state where it is registered, authorized capital etc. 2. Article of Association. It contains rules and regulations with regard to internal working of the company. Rights and powers of the directors, conduct of meetings, business to be transacted by the company etc. are given in AOA. Every person dealing with the company must have read both MOA and AOA and know about the business and the way of doing business by the company. This is called constructive notice. 3. Certificate of Incorporation or Certificate of Commencement of Business. This certificate is issued by the Registrar of Companies and forms conclusive proof that company has been incorporated and has completed all the formalities regarding its formation. The certificate of incorporation of the company is required by both the private limited and public limited company. However, the certificate of commencement of business is not required by private limited company. 4. Resolution. Company acts through its board. It confers powers on the board through MOA and AOA for its functions. For opening an account, or obtaining debt, the resolution shall specifically mention the following. A. Name of the bank where the facility is desired. B. Name of person authorized to operate the account. C. Name of the person authorized to sign the documents for loan. D. The detail of financial facility sought. E. Name of person who are authorized to mortgage the property of the company. 5. Borrowing powers of a company. All companies have implied powers to borrow money for the purpose of carrying on its business. The amounts raised by the director shall be for the company and with powers conferred on the directors by the company through its board resolution. Note that vide Article 293, d, of the Companies Act 1956, the board of director of a public limited company, or of a private limited company held by public limited company, cannot borrow in excess of aggregate of the paid-up capital of the company and its free reserves. The company shall obtain consent in a general meeting for borrowing in excess of the limit. Here note that short-term loans, temporary loan, that is loans repayable on demand or within 6 months, are not included in this limit. Borrowing without authorization. In case a director borrows money without proper authorization but for the benefit of the company and also goes to the company is liable for recovery of the dues. The amount so raised can be ultra vires the director, but not ultra vires the company. 6. Creation of charge or registration of charge. Section 77 to 87 of Companies Act 2013 deals with charge. The company raising loan shall file charge with Registrar of Companies, ROC, within 30 days by filing CHG 1, for other than debentures, and CHG 9 for debentures. If the charge is not registered within 30 days, the registrar can allow registration of charge within 300 days as per Section 125 of Companies Act 1956. A charge is required to be registered with Registrar of Companies within 30 days of creation of transaction. In case the charge is not created, the debt becomes unsecured. The charge with late fee can be created within 300 days of creation of such charge. The application for charge in case of delay is to be filed in Form CHG 10. Condonation for delay. If company does not get charge created even within 300 days, it can seek extension of time as per Section 87 of Companies Act from central government. 13. Societies, trusts, and clubs. The societies for promotion of social, cultural, literature, etc. activities need to be registered under Societies Registration Act 1860. They can also be incorporated under Companies Act 2013-1956. The society gets its separate identity only after its registration under such acts. The society is governed by its rules under the provisions of the Act and acts through resolutions of the Managing Committee. If a society is to borrow, it must pass a resolution to this effect in the Managing Committee, and banker must verify that the borrowing powers of the society are given in its charter, or memorandum, and purpose for which the borrowings are to be raised must be noted. 14. Insolvent. A person when declared insolvent is disqualified from entering into a contract. The property of insolvent gets vested with the official receiver or official assignee appointed by the court. If a customer is having both debit and credit balances, the banker can appropriate the credit balances before receipt of notice. However, amount received after the receipt of notice of insolvency cannot be appropriated. In case of a partnership firm, the insolvency of a partner renders the partnership dissolved. The operations in the partnership account should be stopped upon the insolvency of one of the partners, and new accounts should be opened for operations. The share of insolvent partner will pass to the official receiver. The insolvent partner cannot run the account, and debits incurred after his insolvency will not be his liability. However, insolvency of a director or death of a director of a joint stock company does not have any effect on the operations of the firm, as it is a continuing firm. Doctrine of relation back. The official receiver gets title to property of the insolvent with effect from the date the insolvency takes place. This is called doctrine of relation back. The dealings of the insolvent person from this date are invalid, and all such property interest vests with the official receiver. All property from this date is vested with the official receiver. The official receiver gets title to the property of the insolvent from the date the insolvency takes place, and all the transactions entered with the insolvent after this date are invalid. All property from this date is vested with the official receiver. This is it for this video. Thank you so much for your love and support. Stay tuned for the next one. Till then, bye and stay blessed.